of comparison that I think is important is that this wasn't the first volunteer community solar program that the Public Service Commission had approved. Florida Power and Light had a similar program, the Solar Together program, that the Commission approved that was not appealed. So one point of comparison is Duke Energy's program as compared to a previous similar program that the Commission had approved. And the record shows in the testimony of Lon Huber at record pages 1654 to 55 and 1688 to 90, as well as in the stipulation at page 2843, showed the ways that Duke Energy's program, the Clean Energy Connection program, provided increased benefits to the general body of ratepayers as compared to the Solar Together program. There was an increased percentage of benefits to the general body of customers as compared to the prior program. There was an increased size of the low-income allocation of the program subscription base. There was a capacity carve-out for local government in the clean energy.
But that's not really a rate thing. And I know just because you have so little time, if you could just sort of zero in on the math between the difference between the participation fees coming in and the credits that are going back to the participants. Because it seems like that's really what this hinges on.
Well, I'd be glad to talk about the rates. First of all, it's important to note that the bill credits are not guaranteed under the program. They're based on the generating capacity of the plants. Now, there's certainly projections that the plants will generate solar electricity.
And the certainty of that is there's a lot more than the projections for the all the government, whatever. I mean, that doesn't really seem to be much doubt that this is going to be produced.
Duke Energy is certainly projecting that it will build plants that generate electricity. There's no doubt about that. But the amount of the bill credits is subject to some degree of risk that is taken on by the subscribers on the front end in their subscription fees. So there's some degree of risk there. The baseline comparison here, and this may go to Justice Polston's question, it should not be the existence of these solar plants without a subscription program as compared to the existence of these solar plants with a subscription program. The record evidence showed that but for this program, Duke Energy would not have engaged in the construction of these solar plants. So the record evidence shows what is showing the appropriate baseline to compare this program against in that context.
Why is that? What does the record say that without a subscription program that you would not enter the solar?
There was testimony about that from Matthew Stout, who was Duke's managing director of business development for wind or solar, and he talked about some of the business projections that Duke was having. And there was certainly competent evidence in the record as to Duke's future plans in the absence of this program and this stipulation that was unrebutted by the other side's witnesses.
See, I'm looking, as I mentioned to PSC General Counsel, I'm looking for some benefit that the subscribers are bringing to the table in exchange for what they're getting by way of $300 million worth in credits. I mean, for example, if the numbers were, Justice Lawson was talking about capitalization or the construction and so forth, if the numbers bore that out, that would make sense to me. So I would be looking for something like in the first 7 years that the subscription fees are coming in maybe at a higher amount than ordinarily they'd be paying for electricity with no credits, and that and they're locked in for 7 years. They can't terminate. They're in there and they can't go anywhere. And if they did, there would be some kind of penalty. So that would mean to me certainly a cash flow that would be coming in to fund the construction cost. That would be a capitalization of construction similar to what Justice Lawson was describing. I don't see that. That's not there. So it's something different altogether. So that's what I'm looking for, is where in the record is there some kind of benefit that the subscribers are bringing to the table?
Let me try to point you to a couple places in the record. Page 113 of the record is a chart showing the cumulative present value revenue requirements for this program in a number of different ways, and it does show in the first column that the total fixed revenue requirements for this program are $794.2 million, and that is something that the participant subscription fees in CPVRR terms would equal $833.4 million. So that means that the general body of ratepayers would stand to benefit by about $39 million in CPVRR terms over and above. That's the basis for the 104.9% figure. Recognizing also that the bill credits are not guaranteed. They're expected, they're reasonably projected, but they're not guaranteed. And over the first few years of the program, this is in testimony of Steve Criss for Walmart, over the first few years of the program, the subscribers are expected to lose money. The bill credits that they would receive under the projections, even under Duke's projections, would be expected to be lower than the amount of the subscription fees that they are paying. So they are paying more than they are receiving in bill credits for those first few years as Duke is building the plants. Now, I certainly agree. They are not paying the entire value in the first 3 years to construct these solar plants. But over the life of this, in CPVRR terms, they are paying in subscription fees more than the total fixed revenue requirements to build these plants.
But that's the gross amount, not the net amount. That certainly would not be true on a net basis.
Assuming the bill credit projections, that's true. But there are also other benefits that they would get. They do have, as Justice Muniz said, these subscribers want to subscribe to solar power. Some of them have solar energy goals that they have set out for themselves. Walmart in particular mentioned and testified, unrebutted, that it had aggressive renewable energy goals that this program would allow them to meet. So there are many reasons why a subscriber, why an individual person or company might choose to subscribe to this program. Some of it might be to receive the bill credits outweighing the subscription fees over a long enough period of time. But there are other benefits that aren't quantifiable in those terms as well.
Has there been any comparison, as I asked before, to what they're paying for electricity compared to what, in this program, compared to what they typically pay?
The projections under this program, and I think I'm answering your question, but let me know if I'm not. The projections are that under this program, there would be a net benefit overall in CPVRR terms to Duke Energy Florida's customers of $533 million. Of that, 83.7% of the value would go to the general body of ratepayers, and the other 12.7% would go to the subscribers under this program.
No, that's the allocation of the anticipated savings of having the solar, right? What I'm asking is a comparison of what the subscribers are going to be paying net compared to what they ordinarily would be paying without solar in the same time periods. Any comparison like that been done?
So I think that is the comparison you're asking for, but you don't think so, and your value counts more than mine on that.
I think it would help. No, but I think it would help just for the baseline to make sure we're all on the same page. When people participate in this program, they're not really. It's not like my Walmart is going to be powered by solar energy, right? They're paying money into the overall system, and then solar becomes a greater part of Duke's overall sort of energy mix, right? And so my energy bills, my own particular energy bills, they're going to be whatever they're going to be, right? So the only way that this affects my energy bill is two ways. I mean, one is through the participation credit that I'm paying in, and then to the extent that everybody's bills fluctuate, depending on sort of the overall cost of, producing energy by Duke, then my bills might go up or down. But it's not as if all of a sudden, like I'm using solar energy to pay for my plant, and so therefore my bill is going to go up or down. I mean, am I right about that?
You're right about that. It doesn't, the power line does not go from the solar plant to your house. But the benefit of bringing these additional solar plants into Duke's overall system of electrical generation produces those savings.
Right, and again, that's for everybody. And that's one of the things that, as a layman, that makes it hard to sort of figure this all out, is that the general rate paying body that are supposedly going to realize all these savings, that includes all the participants too. I mean, their rates are going to go up or down depending on how things go. The only thing that's different for them is that they're paying in the participation fees, and then they're getting whatever bill credits they get. True?
That's different, but what's also different is the evidence showed, again, the baseline is not the comparison between this program without a subscription model and this program with a subscription model. The evidence showed that but for this subscription system and stipulation, Duke Energy Florida would not have embarked on this program at this time. So the benefits from this program...
Right, and again, I mean, and this is just, we're not trying to be jerks about this, but to the extent that there's evidence that, but for the participants, it wouldn't have happened, it seemed to me that the nature of that evidence was these companies coming and saying to Duke, hey, we need solar, we need renewable energy credits, we want, sustainable energy, blah, 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 let's do this program. The evidence isn't that financially Duke is saying we want to build more solar, and the only way or the best way for us to do it is to do this thing. Because as a layman, and there may be something obvious that I'm missing, but as a layman, I'm sitting here looking at this and I'm thinking, wow, we build 10 solar plants and all of a sudden, our customers are saving $530 million. Isn't this great? As a layman, you're sitting there thinking, why aren't they just building the solar plants? And if the record showed, well, we'd love to build solar plants, but we can't do it unless we get these participation fees, I could understand that, but I don't see that kind of evidence. What I see is, these companies going into Duke and saying, hey, let's, FPL did this thing, why don't we do one too? I mean, am I wrong about that?
Slightly wrong on that. It wasn't just companies such as Walmart here. We had Vote Solar. We had the Southern Alliance for Clean Energy. Those are nonprofits that support renewable energy. They were also counterparties to this stipulation.
But on the economics of it, let's assume that it was 1,000 poor people that came and said we want solar energy. So I'm not trying to be pejorative about that. But was the incentive economic? And if so, where is that in the record?
I think some of the incentive, and I think you could look at the testimony of Steve Chris from Walmart that says they expected to make some net money off of this program, but that wasn't their primary motivation either.
No, I'm talking about Duke's motivation.
Oh, well, Duke's motivation? I mean,
Yes.
certainly Duke as a publicly traded company has a motivation to make money on its programs. But there was a lot of evidence in this record showing that the rates here were not only, that the program is not only in the public interest, but established rates that were fair, just, and reasonable. Those are factual determinations on a large record after a 2-day evidentiary hearing and after a lot of discovery.
Can I make sure I'm right on the math, and I very well could be wrong, so I want to check this. I show that the subscription payments overall for all subscribers at $833.4 million. Is that correct?
I don't believe so. No, I'm sorry. Yes.
Okay. And that the bill credits back to those subscribers would be $901 million, correct?
That's correct.
So that, if my math is correct, would be a rate of return of about 8%.
And we're talking on the CPVRR.
Yeah, but if you look at it as okay, I'm Walmart, and I want these credits, so I have this incentive to have some solar, or participate in making it happen, and I'm willing to invest however much of that $833 million that's going to go in to actually build the plant and pay for it. What I'm getting back financially is an 8% return on that capital investment. That's looking at it from Walmart's perspective. Is that correct?
I believe your numbers are roughly correct. They're based on the projections that are underlying the record.
And I think what you're saying
alone,
is
they're getting electricity, right?
Okay, but I think what you're saying is the reason why Duke wouldn't do this without this kind of program is that the cost of the plant at almost $800 million. I mean, you put some extra in there, which is smart. It was 700 something million, almost 800 million. If you just use the typical model, you could get a coal-fired plant or some other kind of generator a lot less expensively. I mean, solar is not cost-effective if just the ratepayers are doing it, which is why it hasn't happened. Why Duke wouldn't do it? Is that correct? I mean, if they were just, as a company, going to seek recovery of all the costs, the $800 million, from their customers, then it's just not as good a deal for the ratepayers, so it wouldn't happen. But you have these other folks that are willing to come in and for an 8% return and whatever other incentives they have in whatever the credits are that exchanged, that they're willing to pay for the entire thing, which therefore then makes it a good deal for the ratepayers. Is that?
So I think the record evidence shows that this is a good deal, not only for Duke Energy, but also for the general body of ratepayers and also for the subscribers to the program. In the testimony of Thomas Foster on the calculation of those subscription fees and the bill credits that were associated with the program that talked about why it made sense from the subscriber perspective. You have the testimony of Lon Huber from Duke Energy on the design and the structure of the program, including the benefits of the program and the objectives of the program. And you have the testimony of Walmart's witness, Walmart's Director of Energy Services, Steve Criss, that talked about the reasons why Walmart supported the Clean Energy Connection program.
And again, sorry to interrupt you, but so how are we supposed to know whether 60 million is the right number or 30 million, or if we're looking at the, the net savings? I mean, kind of what I was asking your colleague there. I mean, if it really comes down to, hey, it's a net benefit to the ratepayers, then at least logically, wouldn't that have justified 3 times more in bill credits as long as there's still savings, for the general payers, right? I mean,
so I guess I'd answer this way. The question of whether it is fair, just, and reasonable is not a question for this court to answer in the first instance. This court obviously doesn't sit as a substitute fact finder.
Right.
The commission makes that determination, and
Right.
this court reviews to see if there's evidence in the record to support it.
So but isn't it a judgment call? I mean, there's no evidence that $30 million of a net in the credits wouldn't have gotten the job done, right? I mean, how am I supposed to, if I put yourself in my shoes, how am I supposed to know? How am I supposed to evaluate whether the 60 million is fair?
I think if I were to put myself in your shoes, I would say that your job and this court's job is to not determine whether the 60 million is fair.
How they concluded that it was fair.
Because, and the answer to that is because it is, to some extent, a judgment call based on the facts presented to them, based on a comparison of all of the expertise that the Public Service Commission brings to the table on other rates charged by other companies, and all of that together, do they determine whether it's fair, just, and reasonable as a factual determination. This court reviews the findings to see if there's evidence, any evidence that a reasonable person would rely upon to support that, and whether it's in the public interest, not only as to rate, but as to all of the non-rate factors. Unless the court has further questions, I'm well over my time, and I appreciate the extra time.
Thank you. Justice Lawson, addressing your question about the rate of return, if you actually look at the initial years as when subscribers are expected to be paying net into the program, and say for every dollar that they invest in those initial years, how much are they going to get back? It's 135 to 1. That is the record evidence. There's
Go
no
through that
dispute
math
with
with me. I don't understand that at
Sure.
all. What are the
If you
numbers?
look at the initial years, so this is, again, hearing Exhibit 8, and this was the exhibit that was just referred to by my colleague, which is record page 2046. And you look at each, just go year by year. So in 2023, the participants are on net expected to pay into the program $500,000. In 2024, they're expected to pay into the program $800,000. In 2025, they're expected to pay in $200,000. After that, they start getting paid. In 2026, they get paid $500,000. Then it just goes up from there. 1.2 million in 2027.
But are the present value numbers that I used accurate? In other words, is the total amount that goes in on a present value basis 833.4 million?
Well, it's a sort of a tricky question because that doesn't take into account how much they're being paid every month.
Well, we're going to get there. It doesn't seem tricky. What's the total amount of subscription payments on a net present value basis? I have it as 833.4 million.
Yes, that is true.
Okay, good. And the total bill credits back are more than that at 901 billion. Is that correct?
Yes, that's correct.
And so overall, if you look at the present value, that's an 8% return.
Yes, but that doesn't take into account how the bills are actually being paid. It's not like they're paying that 833.4
Well, is there
million
some
up
law
front.
that says that the commission has to get into that detail and decide that the schedule needs to be a certain amount per year, and that, I mean, it's just...
Well, when we're hearing that the participants are paying for the program, when it is undisputed that these solar power plants are rate-based, and you look at all those initial years, and it's actually the general body of ratepayers paying over 99% of the cost of the program, and then more than 100% because they have to pay now, after those first initial years, net bill credits to the participants.
So when you say that the ratepayers are paying, what you're talking about is the projected cost of the electricity that's ultimately produced from this and other sources? Or from
No,
this
I'm
source?
talking about these solar power plants.
Look, I think isn't your point that we don't care what Walmart's rate of return is? That we're here to see whether Duke has shown that this program is fair to its overall ratepayers. And so the question that we need, that was before the commission is whether, given what the ratepayers are going to pay for the value that they're getting from the participation fees, that's the question. Whether Walmart wanted a 10% or a 5% or whatever, the point is the ratepayers are supposedly getting this $530 million benefit. They had to pay the participants the $60 million to get it, according to the logic here. And the question is, could they have paid 30 and gotten it? Would they have, if they had paid 200 million, would that have been appropriate? And how are we supposed to, given the record that we have, how are we supposed to figure that out?
I'd say given the record that you have, given that these solar power plants are rate-based and being paid for by the general body of ratepayers, anything above zero would not be fair, because that is showing an undue preference for the participants.
So it seems though that you're discounting though the possibility that the participation fees actually were necessary to get these plants off the ground. And it doesn't seem like the evidence. So it seems like you're wrong on that.
Well, I would push back on that, Your Honor, because on cross-examination, Duke admitted that the participation fees do not meaningfully contribute to the cost of the plants, even in those initial years, that the burden is still on the general body of ratepayers. Yes, we have Duke's testimony that they would have built less solar power plants absent this program, but they were never able to substantiate why that's so. Furthermore, I mean, there is really no risk to the participants. Say, we heard about risk to the participants. That's the bill credits are only contingent on the capacity factor of the plants, which is only contingent on Duke building the plants as designed. And there was lots of record evidence that they do know how to build solar plants. They've been building them. They're building them now, and that they achieve that kind of capacity factor or higher. And so, say Duke completely botches these power plants. They don't work that well. They don't get anywhere near that capacity factor. The bill credits aren't coming as expected. The participants can just leave. They're free to leave at any time. And then the general body of ratepayers is still on the hook for these now power plants that aren't working. So, again, we keep hearing this 104.9% number, but again, the participants are being paid that 104.9% plus over the life of the program, almost $300 million, such that it nets out to be a present value of $67.7 million. Unless there are any other questions, I will sit down with that. Thank you.
Right. We thank you all for your arguments in this case today. The court will now stand in recess for about 10 minutes before we take up the last case on the docket.
All right. Supreme Court of Florida is now in session. Please be seated.
The court will now take up the case of Truhill versus the state of Florida. Counsel?
Thank you, Mr. Chief Justice. Good morning, and may it please the court. My name is Tracy Henry, and along with co-counsel, I represent Quentin Truhill. This case is before this court on the denial of a 3.851 post-conviction motion following an evidentiary hearing. Mr. Truhill's convictions and death sentence should be vacated because they are not supported by competent and substantial evidence. Truhill's counsel was prejudicially deficient in their representation and were
Counsel,
not...
I apologize. I'm having trouble
Oh,
hearing
I'm
you.
sorry. Is this better?
That's a little better. I
Can you
think.
hear me now? Truhill's counsel was prejudicially deficient in their representation and were not acting as the counsel that were guaranteed to Truhill under the Sixth Amendment. If the jury had heard the truth of the evidence and the full evidence, there is a reasonable probability that the jurors would have seen that the circumstantial evidence presented by the state was inconsistent with a reasonable hypothesis of innocence, or at least would have raised doubts about Truhill's culpability in comparison to his co-defendants. In this case, all of the evidence that the state used to connect Quentin Truhill to the murder of Vincent Binder was circumstantial. The prosecution relied on testimony regarding a series of uncharged collateral crimes and relied even more heavily on DNA evidence. In Claim 4 of our brief, we assert that Truhill's convictions and death sentence are unreliable because they're based on weak DNA evidence that should never have been heard by the jury, or at least should have been effectively confronted by defense counsel to expose the weakness of the DNA evidence.
Counsel, where can you point to as far as the DNA evidence that squarely places Truhill committing the murder?
There is no DNA evidence that squarely places Truhill as committing the murder.
And where was there testimony that there was DNA evidence that suggests that he committed the murder?
Oh, there's a great deal of evidence that suggested Truhill.
What
A great deal of testimony that suggested that. Specifically, regarding the DNA evidence, and the state relied heavily on this, one of the items of evidence was the machete. It was State 63, and everyone referred to it as the machete during the course of the trial. And what the jury heard regarding this machete was that while there was no blood found on it, the FDLE analyst found a partial DNA profile on the blade, a single source profile. She linked Quentin Truhill as the possible source of this DNA based on two locations. The state made much of this in closing, and they said that Livingston had found two genetic markers on the knife that matched Truhill, and this court even noted the same in its opinion on direct appeal. The jury yes.
The opinion on direct appeal said the DNA evidence places Truhill at the scene.
Yes.
Is that correct?
Yes.
So are you arguing today that it did more than that?
What I am arguing today is that this court and the jury did not hear all of the evidence, and what was in front of the court may have placed him at the... No, I'm not going to say that. What I'm saying is that neither the jury nor this court had the benefit of all of the evidence and had the benefit of the true understanding of the DNA evidence, while it may have appeared based on what was presented at trial that Truhill was at the scene.
Help me understand the role counsel might have played, given the concession you just sort of made.
Sort of. I'm going to walk that back.
To support some genuine hypothesis of innocence.
Oh, absolutely. Defense counsel had a myriad of failures, actually. First and foremost is that they hired a DNA expert that not only refused to testify, but refused to enter the courthouse in order to assist with cross-examination. And they knew this before they hired the expert. They knew that this was someone who was not entering the courthouse. What little advice that the expert did give them regarding the weakness of the DNA evidence, they ignored and did not bring it up on cross-examination. They failed to
And your
obtain-
position is there's no tactical reason why they might have made that choice?
Absolutely no tactical reason whatsoever, and at evidentiary hearing there was no testimony as to why they hired this person, knowing full well that he wouldn't come to the courthouse other than the fact that they had worked with him before.
Let's say hypothetically that a piece of DNA evidence proffered by the state says, gives us a 1 in 1,000 chance to believe that a person was at the scene. And let's say hypothetically that your expert says it's actually 1 in 2,000. Defense counsel is barred. You want it to be the law that defense counsel is barred from calling that expert because whether it's 1 in 1,000 or 1 in 2,000, it could just be corroborative enough for the jury. We're not going to get into that. We're going to make some other argument. You think that kind of analysis is never tactical?
In some cases, that kind of analysis may be tactical, but in this case, absolutely not. One of the things that, in talking to the 1 in 1,000 and 1 in 2,000, that is actually a very important measure that was not addressed at trial. In DNA mixtures, pretty much all of the DNA evidence that was presented at trial, aside from the machete that I just mentioned, was a mixture, and was not just a simple mixture of 2 people, but more of a complex mixture, 3, 4, 5. We don't know how many people on some of these items.
Counsel, I'm gonna stop you for a second. You did a great job in your brief of laying out this argument. So let's say we accept that. Let's say we agree with you that there was this key point missing from this DNA evidence. It seems to me that the entire theory of defense here was never, and I think rightfully so, that he wasn't there. I mean, there were numerous situations where he was identified, he's on surveillance cameras, he's identified by the victims, he's in the vehicle where all of these items of evidence are, he's at the hotel room where they found even more evidence. I mean, was this ever, are you standing here arguing that they should have said he wasn't there at all, and that was their basis for their defense, and that's where they're deficient? Are you pointing to this DNA evidence for some other reason?
Bit of both. What we have with the DNA evidence, and I will accept your premise that we can throw away all of the DNA evidence. I will happily accept that premise. And what we are left with after we take away all of the DNA evidence is uncharged collateral crimes. Yes, inextricably intertwined, as this court found, with the murder of Vincent Binder, but nonetheless uncharged collateral crimes that cannot be used to convict him of this crime. It can be used for a number of other reasons, a mistake or planning or whatever else there is. But what the state did prove in the absence of the DNA was that they escaped from jail in Louisiana, Peter Hughes, Quentin Truhill, and Kentrell Johnson. They did prove that they stole a truck. They proved that Leanne Williams, who was one of the victims of the uncharged crimes, was robbed by these 3 men. They also proved that the person that did rob her was not Quentin Truhill, because she testified that the person who robbed her was bigger than her, and Quentin Truhill was not. They proved that Brenda Jo Brown was attacked, but again, this was not charged. Brenda Jo Brown did testify that she saw Quentin Truhill with a knife, but she doesn't know who hit her. She doesn't know who attacked her. She did not see that, so she was not able to say that Quentin Truhill was the person who attacked her. All of these are inferences that the jury needs to stack to determine whether or not Quentin Truhill was genuinely guilty of the murder of Vincent Binder. We have the testimony of Mario Rios, who said that Quentin Truhill grabbed him and brandished a knife. We also have the testimony of Mario Rios that he was very easily able to get away from Quentin Truhill. We have the testimony of Chris Pavlish, who said that, yes, Quentin Truhill grabbed her, but he also had skinny arms and he didn't really look very strong and was more interested in her purse than her. And aside from all of this that had nothing to do with Vincent Binder at all the state has as far as direct evidence, well, not direct evidence, circumstantial evidence of Quentin Truhill's involvement in this is that he did use Vincent Binder's credit card.
What about the knife?
Well, we have 2 knives, and different witnesses described different knives in Quentin Truhill's
What about
hand.
the knife I'm talking about the physical evidence of the knife?
The physical evidence of the knife. If we're talking about State's Exhibit 54, which is, that's the one that everyone referred to as the silver knife, and that is the knife that was determined to have been one of the murder weapons because Vincent Binder's blood was found all over it.
And there's no doubt about that.
There's no doubt that Vincent Binder's blood was on that knife, absolutely. Where there is a
Is there any
doubt,
doubt about where it was found?
no, it was found, that one was found in the hotel room, I believe, either that or the truck. But it was definitely found with the 3 co-defendants, yes. And the DNA evidence that was testified, the way that Quentin Truhill was linked to this knife, aside from Brenda Brown's testimony, was that there was a complex mixture on the cutting edge of the blade that could possibly include Truhill, Mr. Binder, Brenda Jo Brown, Peter Hughes, and Kentrell Johnson. And this inclusion was made on one location. And And so what the jury heard was that Truhill's DNA was on what was clearly the murder weapon. But what the jury didn't hear is that a single location gives absolutely no weight to an inclusion, and that Truhill should not have been included on that knife. That the statistical values in the FDLE report, which was not entered into evidence, and the FDLE expert did not testify to these statistical values, was that the probability of exclusion from the mixture was 15%, which is a meaningless statistic because that means that 85% of the entire population could have contributed that DNA. And that according to the state's FDLE expert, DNA expert, Lee Clark, other than Vincent Binder's profile on that knife, any other information was too limited for comparisons. So what they're saying is, what the state is saying in closing is that his DNA is on that knife, and that knife killed Vincent Binder, but had defense counsel done what they were supposed to do, they would have cross-examined and shown how weak this was and that Quentin Truhill's DNA should not have been included on that knife. In a circumstantial evidence case like this, especially in the pre-Bush world, the state's not building a house. They don't have a solid foundation. They don't have eyewitness testimony. They don't have the defendant's DNA at the scene. They don't have video or eyewitness testimony or anything like that. What they're building is more like a pier. So they're putting up these posts. And in a case like this, which is very heavy, those posts need to be strong. And if those posts aren't strong, the case is going to collapse. What the state based their case on was extraordinarily weak DNA evidence, so we've knocked out those posts. So those posts are going to fall down. And then all we have left are people saying, well, yes, I saw Quentin Truhill do this, I saw this in his hands, but all of those require an impermissible stacking of inferences to lead to the conviction of the murder. In addition to that, well, the other point with this, and it's not the testing or of the DNA that's the results, it's the interpretation and the testimony regarding the DNA. And the fact that the defense counsel did not properly cross-examine or confront this evidence in any way. Jurors were instructed that what the lawyers say is not evidence. And what defense counsel did here was attempt to make himself the expert, because he knew that his expert wasn't going to testify. He attempted to make his questions to the FDLE expert the evidence that the DNA evidence was weak. But unfortunately, he did not understand the way that the DNA evidence was working. One, because he wasn't listening to his non-testifying expert, and two, because he didn't have anyone there advising him properly. Defense counsel has the duty to present this evidence, and in this case, it was necessary to do it through a testifying expert. The cross-examination was so ineffective here that Judge Zambrano actually had to stop the trial, call him up to the bench, and say, can you please stop confusing the jurors, the witness, and me? A testifying defense expert was vital, and without that, we can't have any confidence in the outcome of this case. And moving on to, I've got 2 minutes left. Regarding the fact that the DNA, and I do understand that we are talking about a felony murder case here as well. In argument 7 of our brief, we challenged the denial of a hearing on claim 9 of our 3851 motion, specifically the issue that both of Truhill's co-defendants received life sentences after he was sentenced to death. And as such, Truhill we should have gotten a hearing on this claim based on that newly discovered evidence. At the time of his sentencing, the jury and the trial court that sentenced Truhill to death had no idea that his co-defendants were going to get life sentences. And at the time of his direct appeal, while this court was still conducting proportionality review, the court took into account Peter Hughes' plea to a life sentence, but had not yet ruled in Kentrell Johnson's matter. And the decision of whether his co-defendants' life sentences require a life sentence for Truhill is fact-based. It should have been determined after the presentation of evidence regarding his co-defendant's participation in the crime and in the context of the facts. Rule 3851 states that at CMC, the court shall schedule an evidentiary hearing on claims raised by the defendant as requiring a factual determination. And this court has identified the failure to hold these hearings as a reason why there is a massive delay in the post-conviction process.
Doesn't our case law say that as a matter of law, when the co-defendants are receive a sentence other than death because they plead guilty or because of some other legal ineligibility for the death penalty, that's not going to be a basis for determining that the sentence in question should be reduced.
Well, our case law does say that, specifically Judge Zambrano's.
It's not a factual matter, it's a question of law.
Well, in this case, we contend that it is a factual matter because in this case, both juries found Truhill and Johnson guilty of first-degree murder, and the trial judge made very specific findings regarding his reasons for imposing the death sentence. In Truhill's sentencing order, the trial court found that Truhill acted under the substantial domination of another person. He found that it was proven by the greater weight of the evidence, but he gave it slight weight, and this mitigator was not raised in Kentrell Johnson's case. The trial court also found that Quentin Truhill and Kentrell Johnson's participation in the crime was on equal footing regarding the statutory mitigator of the crime being committed by another and the defendant having a minor role. The trial court found that this mitigator was once again proven by the greater weight of the evidence regarding Truhill, also gave it less than slight weight, but regarding Kentrell Johnson, he found that evidence scant and de minimis. And this was after the trial judge had the benefit of seeing the evidence in both Truhill's and Johnson's trials. And this court, in its opinion on Kentrell Johnson's direct appeal, noted that the trial court's sentencing order said that Johnson was older, physically larger than his co-defendants, and that his role was a prominent one. There was also testimony that Johnson gave his younger co-defendants instructions and appeared in charge of the group.
Okay, counsel,
yes.
you are consuming your rebuttal time.
In which case, I will reserve the remainder of my time. Thank you.
Good morning. May it please the court. My name is Patrick Bobek and represent the state in these cases. I want to start with Claim 4 on the DNA evidence. Each one of the claims in Claim 4 attack the DNA evidence of complex mixtures. This case is not built on the DNA evidence of complex mixtures. It's built on much more substantial evidence than that, including 2 full DNA profiles of 2 of the victims. Vincent Binder's blood and Brenda Brown's blood are found on jeans in the hotel room that the defendants were staying in. Full DNA profiles of a single subject, not complex mixtures. Also, as to the machete, now this is a partial single source profile, and it excludes both co-defendants as a contributor and includes only Quentin Truhill as a possible contributor. And the jury was allowed to hear the statistical value of that match, and it was 1 in 190 African-American males, which is not the strongest evidence in the world, but remember, this is a knife found in the hotel room that matches the injuries that Vincent Binder received when he was murdered. In addition, there's a lot more than DNA evidence that connects them to these collateral crimes. Remember why the DNA evidence was introduced: to connect them to these crimes and Binder's kidnap and murder. We have the testimony of Brenda Brown, Chris Pavlich, and Mario Rios, who all said they were approached by 3 black men who accosted them. 2 of those people were accosted in Tallahassee on the same day Vincent Binder went missing in Tallahassee. Leanne Williams' ID card is found in the truck that the men stole and was recovered in Miami. Chris Pavlich's ID card, her social security card, and her high school diploma are found in the truck that the men stole. So this is not an evidence built on DNA. The DNA evidence, while helpful in this case, if anything, was the weakest part of the case. And so I think the court can ignore the science and the SWGDM guidelines and SOPs and jump straight to prejudice on this issue and see that there is none, because there's no reasonable probability that the outcome of the case would have been different had the complex mixtures been excluded or discounted by the jury. As to the co-defendants' life sentences, as Judge Kennedy pointed out, these were for legal reasons. Peter Hughes pled guilty, and Kentrell Johnson essentially had tried to plead guilty beforehand by making a deal with the state that he would lead them to the crime scene in exchange for a life sentence. The state reneged on that deal, and this court on appeal upheld it. So those are both legal reasons, non-factual, non-relative culpability reasons. And for that reason, relative culpability is not an issue. If there are no other questions, I'd ask that you affirm the trial court and reject the habeas petition. Thank you.
Thank you, counsel. Rebuttal.
I appreciate counsel's throwing out all of the entire DNA evidence. But just to correct a couple of things as far as the genes that the Vincent Binder's and Brenda Jo Brown's blood was found on, and that, yes, Quentin Truhill was possibly part of a mixture on the inside of the waistband. The probability of inclusion of any of the co-defendants plus Shirley Marcus on that one was 1 in 24 African Americans. One of the other things that wasn't brought out in front of the jury is that when a DNA analyst does these calculations, one, there has to be all of the evidence there. And in a lot of these, the evidence was weak. This was touch DNA. Touch DNA is not as strong as blood DNA. It is possible for the alleles to drop out. Once the alleles drop out, a DNA analyst cannot be confident in what they're finding. The probability of inclusion on this one was 1 in 24 African Americans. If you look at another thing that FDLE analysts
But counsel, these genes, I mean, was there any doubt that this was Mr. Binder's blood on the genes?
No doubt that Mr. Binder's blood was on the
Is
genes.
there any doubt these genes were found in a room occupied by Mr. Truhill and 2 other people?
In a black plastic garbage bag in a room occupied by Mr. Truhill and several other people.
So even without the DNA, I'm having a hard time drawing where the prejudices from really the testimony saying it could have been Truhill's DNA on this, or it could have been some other people's DNA, which is what the testimony was. I mean, where is the prejudice there?
The prejudice here is that what the jury continued to hear over and over and over again was that Quentin Truhill's DNA was on these items that were associated with the murder. Yes, Vincent Binder's blood was on there, but was Quentin Truhill's DNA on those genes? We don't know, because the levels were so low as to put them in the stochastic range, so that he should never have been included on these. And in fact, Lee Clark of the FDLE said that she didn't know how any part of those genes could have been considered probative because they had been cut up so badly. Where we have the prejudice is essentially the fact that 3 men participated in a series of crimes, and we don't doubt that, we cannot dispute that, but 2 of them got life sentences and 1 of them got a death sentence. And the main reason why Quentin Truhill got a death sentence is because he went to trial first. Charles Johnson knew how to game the system. He tried to plead guilty. He made a deal. Peter Hughes raised the specter of ID, and so that kind of could complicate his case. The way that Quentin Truhill's death sentence came out was arbitrary and capricious because he went to trial first. He had the lawyers that he had. He did not know how to game the system the way that Kentrell Johnson did. And in that case, we have to see whether the fact that because of all of these problems and all of these things that his attorneys failed to do for him leads to the fact that this is an arbitrary and capricious imposition of the death penalty. It doesn't pass 8th Amendment muster, and this court should reverse the death sentence and his convictions, or at the very least, remand for an evidentiary hearing on the relative culpability issue. Unless the panel has any questions, I thank you.
We thank you. We thank you both for your arguments in this case today. The court is going to remain on the bench. Counsel may retire, but the court's going to remain on the bench while I make a presentation to one of the people who serve our court. So. And I'd like to ask our public information officer, Craig Waters, to come forward. I'm going to say some nice things about Craig, and I have a proclamation to present to Craig. This is a very bittersweet occasion because Craig is retiring, and but we want to recognize Craig's amazing career of service to this court, to the courts of Florida, and really to courts all around the nation. Craig has had a truly extraordinary career and has been someone who has paved the path for court public information officers all around the country. When I go around the country and meet with other Chief Justices, people ask me about Craig. He is well known throughout the court systems around the state. So let me, and on a personal note, I want to say how much I've appreciated the opportunity to work with Craig during my nearly 6 years serving as Chief Justice. Over the various terms I've had as Chief Justice, I have been very grateful for Craig's wise counsel and for his consistent commitment to our court system. Craig has truly dedicated his life to our court and to serving the people of this state. And for that, I am grateful, and our whole court is grateful. So let me read the proclamation, and then I'm going to give Craig an opportunity to say a few words. Proclamation in re Robert Craig Waters. Whereas Robert Craig Waters has served the Supreme Court of Florida, the judicial branch, the legal profession, and the people of the state during a distinguished career of 35 years, and whereas Robert Craig Waters worked as a staff attorney first to Justice Rosemary Barquette and then to Justice Gerald Cogan, during which time he created the first Florida Supreme Court website, and whereas Robert Craig Waters went on to be appointed as the first public information officer for the Supreme Court of Florida and began posting opinions and distributing all high-profile case filings of the court on an expanded website, and whereas Robert Craig Waters spearheaded broadcasting and streaming video of all Supreme Court of Florida oral arguments, and whereas Robert Craig Waters began hosting the Florida Bar Supreme Court Reporters Workshop to promote effective relationships with news reporters, and whereas Robert Craig Waters advocated for and fulfilled the Supreme Court's direction to use social media to distribute court-related public information, and whereas Robert Craig Waters founded the Florida Court Public Information Officers, Inc., to support the mission of the judicial branch, promote transparency, facilitate distribution of emergency court information, and ultimately fulfill the court's statewide communications plan. Now, therefore, be it resolved that the Supreme Court of Florida hereby expresses heartfelt thanks to Robert Craig Waters for his dedicated service and immense contributions to the judicial branch, the legal profession, and the people of Florida. And the same is hereby ordered and done in chambers at Tallahassee, Florida, on this 9th day of February in the year 2022. Greg, we thank you. I'd like if you come forward and receive this.
Thank you, Your Honor. May it please the court. I have to tell you, this is the first time I've appeared on this side of these television cameras that I helped install in this courtroom, and it's a little nerve-wracking. I can tell you that I've certainly seen, in the 25 years since the cameras were first installed here, a lot of nervous attorneys. But I'm always mindful of the very first argument we had in the fall of 1997, the very first day when Justice Cogan announced that these events were going to be on live television for the first time. We forgot to tell the attorneys. And one of the first lawyers in one of the first cases got up here at this exact podium and fainted. I will try not to imitate that example today, even though I'm a little nervous myself. I have to tell you, though, it's been 35 years since I first took the oath of office here in this courtroom, administered by my first boss, Rosemary Barquette. I was a brand new staff attorney at that point, right out of law school, green in judgment, but eager to learn what the professors had not taught me. Those were heady days coming at the start of a period of profound change in the nation and the world. We were just at the cusp of the information age, though none of us knew it at the time. Together, we here at the court pioneered the very idea of courts being open and transparent in an online world, and that was something very new at the time. Then we showed a skeptical world, and especially courts elsewhere, how well we could make that work, even under the intense scrutiny of the appeals that helped shape the outcome of a presidential election. I must say, however, that I stood on the shoulders of giants, especially when I first created the court's first website in 1994, and then carried that basic technology forward in time as it changed. Names like Gerald Cogan, Ben Overton, Stephen Grimes, Charlie Wells, Parker Thompson, and Sandy Dallenbert. And of course, I must also thank all of the past and current members of this honorable court for indulging my creative impulses, which were sometimes a bit fanciful. I know at times my ideas must have seemed half mad and a bit starry-eyed, and I will admit some of them were. Despite it all, the court gave me more than ample room to innovate, with the communications technology that first began emerging in the 1990s. And it let me make openness and transparency the twin themes of my career here. I know how lucky I am to have the highest court in the state give me that kind of indulgence. It has been the highest honor of my life to do this for the past 35 years. It still is today. It always will be. Thank you so much for the wonderful opportunity to serve you here at the court and the great people of the great state of Florida. And may God bless this honorable court. Thank you.
Thank you, Craig. We're going to have some other opportunities to recognize Craig's career of service to the court and to the people of Florida. But for now, this session of the Florida Supreme Court is adjourned.
All rise.